All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Yes, Mr. Lodge.
Thank you, Madam President, and good afternoon to everyone. I will address the last mitigating circumstance relied upon by the defense, which are Mr. Abd-Al-Rahman's words and actions in favor of the victims. This topic is addressed at paragraph 91 to 11 of the defense submission. I do not repeat my submission. At paragraph 149 of its written submissions, the OTP submits that Mr. Abd-Al-Rahman is yet to express remorse and, I quote, continues to assert the lie that he is not Ali Kushaib and refuses to take responsibility for the crimes for which he has been convicted. This was anticipated, and we dedicated paragraph 96 of our written submissions to this topic, but I will just complete in response to what my learned friend from the OTP said. No, Mr. Abd-Al-Rahman has not expressed remorse because he could not. Any remorse or admission that he is Ali Kushaib would have amounted to a confession of his guilt.
Mr. Lodge, I can stop you. I agree. He's contested the case, and it would be, can I put it this way, improbable if he suddenly changed his mind and admitted at the end. However, what is difficult, it seems to me, for you to advance in that event is sympathy that he feels for victims when the trial chamber has found that he is, as I said to Mr. Edwards, he is responsible for the deaths, the torture, and the general ill treatment.
I will respond immediately to this, Madam President, because you said it earlier this morning, so I had the opportunity to prepare the response. In full respect, I think this is conflating two different aspects. The first aspect is the actions that you have found Mr. Abd-Al-Rahman committed in 2003 and 2004. The second aspect is his subsequent efforts in favor of victims, which I will develop very, very soon. Rule 145 2A2 of the rules identifies efforts in favor of victims as a mitigating circumstance. And of course, this mitigating circumstance is designed to play in favor of a person who has been convicted. Can I have the text, please?
Yeah, you need the text, Mr. Lauchi. I think it was Mr. von Wistinghausen who pointed it out. 143 2A2, the convicted person's conduct after that, including any efforts by the person to compensate the victims. That means him personally compensating with the sale of his properties in Rahad al-Badi, for example.
And I will cover that point fully this afternoon. That's in my submissions.
All right. Okay.
But what I want, just the only thing that I want to say here is to say that Mr. Abd-Al-Rahman's words and actions after the facts, after the period that is covered in your trial judgment, may, if it amounts to one way or the other compensation under 145.282, be considered a mitigating circumstance, and that's what I'm going to explain and try to convince you this afternoon. Which means that because this provision is provided specifically for persons convicted and found guilty, this cannot be made empty by the fact that, yes, indeed, they were guilty. Yes, you found Mr. Abd-Al-Rahman guilty, but nevertheless, I will ask you to consider mitigating circumstances on the basis of his words and actions since the period of the judgment. Merci. So I take from your intervention, Madam President, that there is no need for me to insist more on the remorse aspect, and I move immediately to the other aspects.
You did raise, or somebody raised, the Al-Mahdi question, but I had a look at it, and it's clear that it was the plea of guilty plus his actions thereafter which showed remorse, and that doesn't really apply in your case. But as I say, it is not something the trial chamber would expect.
I remember you saying yesterday, Madam President, that each case was different, and I think we can agree on that. I move to the expressions of solidarity with the victims and why these, in the defense submission, these fall under 145.282. Mr. Abd-Al-Rahman has expressed his solidarity for the victims in Darfur on two occasions, the two occasions that he had to do so before this court. Relevant abstracts from his earlier interventions are quoted in the written submissions. I will not repeat these. In addition to these, Mr. Abd-Al-Rahman requested on two occasions that a minute of silence be observed in the courtroom in memory and prayer for the victims in Darfur. The first time was his initial appearance on 15th of June 2020. That's transcript number 1, page 22, lines 4 to 22, and it was denied. The second time was before his first appearance before the appeals chamber on 8 October 2020, and that's the filing ICC 0205 0120 175082. It was again denied. The decision denying his request are, of course, out of his control, but they do not change anything to the fact that Mr. Abd-Al-Rahman repeatedly requested the opportunity to have these minutes of silence and express compassion for the victims in Darfur, which makes that these expressions of compassion and solidarity have been persistent throughout these proceedings. They remain persistent. Tomorrow, Mr. Abd-Al-Rahman will speak a last time with your authorization, and you can be confident that this will be another opportunity to do so. The repeated expression of solidarity for the victims, of course, are worth what they are. But the OTP has no ground to submit that these expressions are not genuine Mr. Abd-Al-Rahman's expression of solidarity in favor of victims are not directed at the OTP anyway. The primary audience of this word is not even in this courtroom. The primary audience are the victims and the affected community who can see and hear Mr. Abd-Al-Rahman expressing his compassion and solidarity through the broadcasts and the outreach activities. I stop here. My learned friend, legal representative for victims, told us yesterday, or I lose track of time, that the victims are not received these expressions of interest in a very positive manner, and that's an euphemism. The way they are received by the intended audience is unfortunately something that is totally out of the control of Mr. Abd-Al-Rahman. He does what is in his power, that is to express his solidarity. The way these expressions are received, he has no control over it. But these expressions of compassion and solidarity already form part of a process of reparations that Mr. Abd-Al-Rahman has been calling for since his arrival at the court, and that's the filing of 17th of July 2020, number 98 in the records. Mr. Abd-Al-Rahman's repeated request to start the reparation phase in favor of the victim without waiting for the outcome of his trial have been denied. This was respected, but these denials have not prevented Mr. Abd-Al-Rahman from starting to offer reparations to victims by his own limited means through his interventions in the proceedings. Mr. Abd-Al-Rahman claims reparation for the victims at the same time as he claims his innocence. There is no contradiction, not even a tension between these two aspects of his positioning before the court. One can be innocent while suffering the torment of the victims and wishing to offer them comfort.
But I'm sorry, Mr. Lacci, but I am going to intervene here because, as you say, the likelihood is that people in Sudan or in Darfur are listening, or may be listening to this. The fact remains, you've asserted your innocence, Mr. Al-Rahman has asserted it, but we, the trial chamber, have found that that assertion was untrue, and we have convicted him. And by convicting him, it means we find him responsible for the death of these people who are having to listen now, to, for the death and the injuries and all the rest of it, who are now having to listen through you to him expressing sympathy for people that we have found were his victims. And I mean, to continue in this vein, you can, of course, Mr. Lacci, but you said that you have no control over how victims have received these expressions of sympathy, but on their behalf, Miss von Wistinghausen has told you. And therefore, it's entirely a matter for you, but I wonder whether it's in your or your client's best interest to continue like this.
Madam President, Mr. Abd-Al-Rahman's first and second expressions of compassion may not have been received in a way it was hoped, but this does not discard the possibility that the third one may be more successful.
Well, all right, Mr. Lacci, I'll let you continue.
Throughout his trial, Mr. Abd-Al-Rahman has seen victims after victims appearing before this court, before this chamber, and explaining what they had gone through. all of us in this courtroom, listening to the victims and the witnesses, where we have all been moved by what they were telling us, does that make us guilty? Why is it that Mr. Abd-Al-Rahman could not have felt the same emotion, the same compassion as we did, and even closer solidarity, because he, unlike us, knows the conditions of living in Darfur? Why the fact that he was accused and that he has been found guilty by your chamber, would that prevent him from feeling and sharing this emotion when listening to the victims and witnesses? Being an accused or even a convict is not a vaccination against compassion for the victim of the crime. Mr. Abd-Al-Rahman was accused. Mr. Abd-Al-Rahman has been found guilty by this chamber, but that alone cannot prevent him, even less so forbid him, from feeling compassion for the victims of the crimes he is accused and found guilty of, and for expressing his compassion to the victims. The Office of the Prosecutor has full discretion to disbelieve his sincerity, but that is irrelevant. The only thing that matters is that the victims of the crime can hear, if they want, the person accused and found guilty of these express his compassion and solidarity for them is in his own words and on repeated occasions. That already, we submit, forms part of a reparation process. But words are not all. Words of compassion are little compared to actual proof of compassion, and I now turn to this. At paragraph 98 of its sentencing submissions, the defense reminds this chamber of the application of 17th of July 2020 to open immediately reparation proceedings in favor of the victims without waiting for the outcome of the trial. This application, of course, was made upon instruction from Mr. Abd-Al-Rahman after full discussion of its implications. And I will mention two. In the first place, the first implication was the possible, even though inappropriate, inference that some may have drawn from this application that he must have been guilty, or otherwise, he would not have cared about reparations for victims. The defense had to be extremely pedagogue to try to rebut that inference, and let me say that I'm not sure we were always successful. The second implication was the possible consequences that Mr. Abd-Al-Rahman would face should he eventually be found guilty, that is now, at the end of his trial. None of these possible adverse consequences were enough to dissuade him from instructing his defense to file the application. The interests of victims prevailed on that occasion. More recently, the defense, still acting on behalf of Mr. Abd-Al-Rahman, contacted the Trust Fund for Victims to inquire about reparations for victims in the Sudan situation. Paragraph 99 of the submissions of the defense. A meeting took place with the Trust Fund on 4 November. I precise that this meeting had been requested since September 2025, but the Trust Fund was not available earlier. During that meeting, the Trust Fund advised the defense that there were currently no assistance or reparation programs in favor of victims of the Darfur situation, and that these would start with the issuance of a reparation order by your chamber and not before. The Trust Fund also advised that in the absence of ongoing program, the fund had no possibility to receive earmarked contributions from private donors for Darfur victims. Should the trust fund receive such earmarked contributions, it would have to see and determine how to deal with these, but there was no ready-made solution precisely in the absence of such earmarked contribution received. Finally, the trust fund advised that its fundraising activities were primarily targeting state parties. On the basis of that information, and after thorough discussion with Mr. Abd-Al-Rahman, the defense sent on his behalf letters calling states to consider making earmarked voluntary donations to the trust fund in favor of the victims in Darfur. The letters have been sent in two batches. The first one of 54 non-state parties, and after consultation with the trust fund to ensure that this would not interfere with their own fundraising activities, a second batch of 114 state parties. Sudan is not on the list of state parties which have been contacted. The defense not only calls for earmarked contributions for the Darfur victims, but offers to meet with states' representatives to answer their questions and facilitate their donations to the trust fund. In short, at the request of Mr. Abd-Al-Rahman, the defense team and its limited resources are actively engaged in fundraising activities in favor of Darfur victims from now on and for an unlimited period of time. This initiative is without precedent in the history of the court and in the history of international criminal justice since its origins. It is by far exceptional. As such, it should heavily weigh in your determination on mitigating circumstances and on the sentence that you will elect to impose on Mr. Abd-Al-Rahman. And please, Your Honors, don't go the easy way of saying that all these actions are at no real cost for Mr. Abd-Al-Rahman. Of course, Mr. Abd-Al-Rahman is not offering to pay for reparations for victims out of his money. And this is for the simple reason that he has none. I have taken the additional instructions. I come to this. Let me remind you that his monthly salary as Musaid within the Central Reserve Forces in 2020 was 660 Sudanese pounds per month. Back in time, at the time of the initial appearance in June 2020, this equated about 12 euros per month. You may wish to check the current equivalent of 660 Sudanese pounds today. I did it on 15 November. On that date, 660 Sudanese pounds equated 0.93 euros. That was his salary per month. Even if Mr. Abd-Al-Rahman offered the equivalent of his monthly salary to the trust fund, that would be no more than €1 per month. Well, I prefer not to know what the OTP would have to say about the mitigating impact of such a donation. Coming to the houses, I can report the following. Mr. Abd-Al-Rahman has a house, a straw house, in Riyadh el-Baldi, where two of his wives live with 7 of his children nowadays. This house, he bought it in 2013 with the money that he received after selling the house that he had in Garcila. He left Garcila, he moved to Riyadh el-Baldi, he bought there a house that could welcome he and his family. The price that he bought it, out of memory, in 2030, the price that he bought that house was 25,000 Sudanese pounds. I made the conversion at today's rate. This amounts to 35.85 euros. That's the cost, the price of the house in Riyadh El Berdi. Mr. Abd-Al-Rahman has a second straw house in Garcila, where his third wife lives with 5 children. And he has this house since, out of memory, 1996. Oh, sorry, did I say Garcila? Oh, sorry, no, my mistake. It's Niala. That's the house in Niala. So, Mr. Abd-Al-Rahman, I start again. Mr. Abd-Al-Rahman has a second house, a straw house as well, in Niala, where his third wife lives with 5 children. This house, he has it since, out of memory, 1996. I asked him the price at which he has bought the house. I got a response. I checked 2 times. It is so low, I dare not sharing that with the chamber unless you really insist. But let me tell you that it's hard to believe how low the value of this can be.
Mr. Archie, I'm perfectly prepared to accept that, particularly these days in Sudan, that the property is pretty worthless. But in fact, this originally started with Mr. Edwards assuring me, and you, I think, yes, that he had no property left. Which is, it turns out, he says something different to the...
Okay.
So wait just a moment. I'm quite finished. Also, he told the person who prepared the report that we've been referring to that he had 11 children, 2 of whom have now died. Now you tell us he's got, and you told us earlier he's got 5 minor children, and now we've got more children.
No, it's the number of 11 is inaccurate. The number was 18 or 19? Initially, 18 or 19? 19. 19, 3 of them died, makes 16 remaining. So that's the correct number. Now, regarding the assertion that he had no property, I'm totally prepared to accept the blame. Mr. Abd-Al-Rahman has these 2 houses, but in full honesty, the value of this, in my respectful submission, is equate no property
it's
at
not
all.
that. It's I'm perfectly prepared to accept that. Equally, my recollection is that he had more than 1 house in Wad al-Berdi because he was. It was suggested to witnesses, or witnesses were saying that he put up refugees in his houses.
Yes,
plural.
precisely. And I can explain this one. As I said, the house that he currently has in Riyadh El Berdi was purchased in 1993 when he moved from Garcia. Before that period, he still had some, I don't know exactly how many, but some members of his family were in Riyadh El Berdi while he was in Garcila, and they were living in the suburbs of Riyadh El Berdi. That was sold as well to purchase the house that is more in the center of the city. So that's the house that is left.
Yes, all right.
And to be complete, Mr. Yedenwarts asked me to clarify, two of the children died since Mr. Abd-Al-Rahman is with us before the court. One died a long time ago, which makes a total of 3. And finally, no more cows. The last 2 cows that he had passed as well. Every money that Mr. Abd-Al-Rahman earns, and my learned friend already mentioned that, out of his work in detention goes to the family. Every single euro that Mr. Abd-Al-Rahman would deflect from supporting his family would expose them to dire consequences, and we submit that this cannot be required from him. So the question is, because Mr. Abd-Al-Rahman has no money to offer for reparations to victims, does that mean that he cannot receive mitigation pursuant to Rule 145-2A2? Rule 145-2A2 provides that the convicted person's efforts to compensate the victims should play as a mitigating factor. The rule does not specify that such effort should be of a financial nature. To interpret it so would amount to depriving persons who, like Mr. Abd-Al-Rahman, have no money from the benefits of this mitigating circumstance. This interpretation, we submit, is excluded under Article 21, paragraph 3 of the statute, which requires the interpretation of the law to be without adverse distinction, founded on grounds such as, I quote, social origin, wealth, birth, or other status. Mr. Abd-Al-Rahman's efforts in favor of reparation for victims, even if they are not of a financial nature, are a mitigating circumstance we submit under Rule 145-2A2. By the way, if you allow me to make a short digression, my reference to Article 21, paragraph 3 of the statute also applies to my learned friend's legal representative for victims' proposal of relying on Mr. Abd-Al-Rahman's profession as a pharmacist as an aggravating circumstance. Article 21, paragraph 3 forbids adverse distinctions founded on grounds such as, and this is not limitative, social origin, wealth, birth, or other status. Being a pharmacist has nothing to do with the crimes, and it cannot be used as an adverse distinction for the purpose of aggravating circumstances. You are fully authorized to weigh his profession. Is there something unclear in what I said?
I'm not sure.
Let me check if I can see it.
I'm just rereading what you said, or attempting to read what you said. Yes.
Was something unclear?
Yes, I don't think, Mr. Lauchi, that Article 21(3) has anything to do with the fact that he chose to, whilst he was in the army, apart from his other activities, take medical training, and then, as the Chamber found it, he committed crimes personally, including the use of an axe, which, because of his training, if nothing else, he would have known would cause serious injury, and indeed, as the Chamber found, kill 2 people. And it surely is is it not, an aggravating feature of his crimes that he had the medical knowledge to know what effect they would have?
Madam President, I would respectfully say that it doesn't take to have a certificate in medicine to know that a hit with an axe can have bad impact on the health of the target. That's obvious for everyone. I'm not a doctor, but I can tell you so. Which means that the medical background and the fact that Mr. Abd-Al-Rahman was a pharmacist, once again, I insist, has nothing to do with what you have found him guilty of. This is his profession, this is his status, and Article 21, paragraph 3, that's my submission, forbids to use that as an adverse distinction for the purpose of aggravating a sentence.
So is that because, for example, I don't want to, it's a very small point, I don't want to spend too long on it, but for example, a doctor has to take a Hippocratic oath, which is
Yes.
not to kill or do any harm or whatever it is. And if that doctor goes out and deliberately commits crimes such as beatings, torture, murder, does that, in your view, aggravate his responsibility or not?
The fact that he is a doctor has no impact on the gravity of the crimes.
No, but on his own personal mitigation, if you like. The fact that he has taken an oath to uphold life and deliberately and consciously goes out and kills. You say that's not a factor.
That, once again, my understanding of Article 21, paragraph 3 is that this factor, being a doctor, cannot be used as an adverse distinction.
Right. Yeah.
That's what I have to say.
I just want to know what...
Yeah.
No.
But the fact that he is a pharmacist, we included it as a mitigating circumstance, because once again, this is not an adverse distinction. This is a distinction in favor, which is not forbidden under Article 21, paragraph 3 of the statute. So, to complete, Mr. Abd-Al-Rahman, with no financial capacity to offer reparation for victims, contributes to these by every other means available to him, that is through his words, again tomorrow, through his instructions to his defense, to ask for the opening of reparations, and to engage actively in fundraising activities for victims in Darfur through the Trust Fund. The defense is asking your honors to give substantial weight to Mr. Abd-Al-Rahman's persistent, exemplary, and unprecedented contribution to alleviating the suffering of victims in your determination. That closes my submission, Madam President.
On this aspect?
Yes.
I see.
No. You want me to address?
Mr. Edwards said that you were going to address the parts that the prosecution
Absolutely.
and the representative victims were made. Firstly, you argue as mitigating circumstance A at paragraph 27 that he had a subordinate rank and low hierarchical position, and the prosecution and indeed the CLIB dispute that and say this is not the case at all. In fact, you also stated in paragraph 27 that the Chamber finds that he was at best one amongst several local leaders of the so-called Janjaweed, implementing orders received and or acting under the authority of higher-ranking officials from the Sudanese armed forces such as Hamdi and Ali Taib. Now, you quoted a whole load of references for that. And I would simply like you to refer us to a specific reference where we say that he was under the command of Hamdi or any of the others, other than, as he said himself, he was reporting to Hussein and Haroun.
President, this will be for you a very easy issue to resolve. Our submissions rely entirely on your trial judgments. The paragraphs that we want to rely on are there. It's up to you to see whether these paragraphs are supporting our submission or not. That's what we have to say. And of course, I will not relitigate anything that is in your trial judgment. We simply rely on the findings that are in the footnotes 48 to 96, to 56.
All right, because as you know, both prosecutions and CLRV say that so you're just leaving it at that, right?
Yeah, it's not a big surprise that we can disagree.
Okay, just a moment.
And the same, if that can help with obeying orders, mitigating circumstance B, I can do nothing more than referring you to paragraph 34 to 36 of our written submissions and the paragraphs of your trial judgment that we rely on in footnotes.
Yes, so what do you say to... But there's more than that. I mean, the CLIV say in terms that, and it's nothing to do with the judgment, that it wasn't a question of obeying orders. Let me find what they actually said.
Madam President, if that can save you time, really, my answer is limited to what is in our written submissions on this topic. I have nothing to add to it.
You have nothing to add in the light of what prosecution or...
No.
Oh, I see. All right. Okay. Yes. Right. I think you dealt with... all the other
Yeah.
matters. Yeah.
Apparently, on the number of children, I am corrected after verification, so the total was 18. 3 died, 2 over these years, 1 sooner in the past, which means that there are 15 children now. And that corrects what is said at page 91, line 6 and 7 of the real-time transcript of today.
Yes. All right. Yes, thank you, Mr. Lecce. Right. I think we should go back then. I don't mind who goes first, either to the prosecution or to the representatives of the victims. Unless you want time. But as I say, Mr. Nichols, I do want to hear what the prosecution say about this business of the foreseeability of sentence.
Yes, Your Honor. I'll try, but I have some other responses
Okay.
to what comes out today as well.
Right. Okay. Whichever. Yes. Well, whichever. Of course, whichever way you want to deal with them.
And so then, sorry, I got a little confused. So then, after this, we go back for another session to the defense.
I think-
Sorry, I honestly got a little bit.
Yeah. You're not as confused as I am either about the order of
I
things.
thought they were going to finish and I was going to go, but I'm happy to.
I don't actually follow. First of all, yeah, Mr. Lecce, you haven't finished, or you, because you say you want to hear what has been said, and then you have another go.
Well, what you have decided in the communications that we received by email was that there would be 2 rounds of submissions for each party and participant. The first one was essentially, well, we can use it the way we want, but the way the defense used it was to respond to the written submissions of our colleagues.
And they did the same for you. Yeah, they responded. To your,
That is done. So the first round, 5 minutes ago, is completed.
Yeah.
Now, normally we should have had witness D16 in the middle, but that worked out a different way. So now what I understand is that we go for the second round for each party and participant, and for this second round, when you inquire about the time that we each party would need, our answer was 1 session for the defense.
But what haven't you, aside from Al-Rahman not giving evidence, giving evidence, nothing, making some closing remarks, what else do you want? You covered everything. You say you don't want to add.
I have not covered everything. I have not made my final submissions, and the final
Right.
submissions are about issues that are not in reply to the written submissions. So that means on aspects that were not covered in the written submissions of my learned friends.
All right. Okay. Right. Okay. Well done. Right. Okay, Mr. Nichols, you then go ahead in any order that you want.
Thank you, and good afternoon, Madam President, and your honors. I'll get to your question towards the end, but just a few points that have come up over the last day or so. Just firstly, to correct I think a good faith mistake on the chart that my friend showed yesterday, which showed recommended sentences by the OTP in one column, and then maximum or possible sentences in Sudan in the other column. There was one mistake there. I didn't want to interrupt, but it stated that in count 5 on that chart, we recommended 5 years, but if you look at our brief, we recommended 10. It's not a big deal. I just wanted to correct that.
I fully trust you. It's accepted.
Yeah. Also, just to note, while talking about that chart, and my friend explained it, that he wouldn't put on sentences that couldn't be imposed here in order to avoid confusion, but that meant that chart for sentences like murder left out the death penalty, left out crucifixion, and so they confined it to terms of years, but it did not accurately necessarily reflect the ultimate severity of the punishment that could have been imposed domestically. Some other quick responses. My friend said today it was mitigating that, or not mitigating, but asked you to take into account that their client was not convicted of personally raping anybody. There's no hierarchy in modes of liability. He has been convicted of 16 rapes, including elderly women, older women, and children. The fact that he has not been convicted of personally raping one of these people, I would say, diminishes virtually nothing. A lot of talk about his age and surrender. I'll combine those two because I think they kind of go together. And you've asked a lot of questions about this, so I'll try to keep it short, but I want to address some points. Again, he surrendered to avoid imprisonment or execution. He delayed that surrender until he was forced to. He likely, I mean, the evidence shows, and from what my friends have said, he never would have surrendered if President Bashir hadn't been overthrown and he faced the prospect of arrest, trial, and then imprisonment or execution in Sudan. So, just briefly responding to my friends, the mitigating value of surrender as an absolute last resort should be extremely low to none. The only incentive that would give somebody is, hey, if you got no choice at all, you're about to be killed, you're about to be put in a terrible prison, surrender and you'll get points for it. Whereas they don't need that incentive because they're doing it to survive. The argument they make, if anything, would incentivize the remaining ICC Darfur fugitives, the ones for whom there are the warrants, or others in a similar position, to wait until they're elderly and then surrender. So if you were to grant this, the message to other persons wanted by this court for crimes against humanity and war crimes is, stay at home, live your life, be comfortable. When you're 69, surrender, and then argue that you're too old to go to prison, and it just wouldn't be fair. It would be the opposite of what deterrence needs to be sent at this point. And to the extent that he is suffering from normal age-related issues, which we don't concede, but those that are natural, that's on him. That's because he waited. If he'd surrendered in 2007, he would have been around 58 at the time. He would have been middle-aged. So this sadness, how sad it is to go to prison as an older person, it's all due to him evading justice as long as he could, until it became impossible to do so any longer, and surrendering was the best option. That is not the message to send, that is mitigating, or mitigating to any significant extent. Good behavior in prison. Well, I would view that, Your Honors, as lack of an aggravating factor is not mitigating. It's expected that one is of good behavior in prison. And my friend said, if you don't give weight to that, then there'll be no incentive for persons awaiting trial to behave. They'll be violent, they won't follow the rules. That's not true, because in every jail, in every prison, there are sanctions for misbehavior. That's how they are run everywhere in the world. And so it's not as though chaos would break out of the detention unit unless there was strong mitigation for good behavior. You questioned quite a bit on this, but I have to briefly address it. This respect for victims, that rings this respect for victims in court, which I'll talk about in a moment, this sympathy for the victims of Darfur, that rings very hollow. First, they would not be victims if not for him. There wouldn't be any need to sympathize with people who lost their family members, who are living in refugee camps now, who were raped because of him. That rings very hollow, and I won't say it's aggravating what they're trying to do, but it is certainly not mitigating. Expressions for other victims of the conflict, I don't have his statements in front of me, but I think in the first one he said, I want to make a statement for all the victims in Darfur. Well, his sympathy, his compassion for victims now, victims not related to his crimes that he's been convicted of, also should have no mitigation. And as I think the LRV said, he can't have his cake and eat it. You know, if he had any, well, I won't say that. Second, there's talk about the respect for the victims and the witnesses. And the defense did not challenge. Almost drank the wrong water. The defense did not challenge the rape victims' account, and that was a good thing to do. That wasn't uniform. You'll recall P878, where the cross-examination started with words to the effect of, "You've told lie after lie to this court." My witness, P907, survived the execution in Deliege, one of the executions. And at T96, page 46, after he finished his testimony, this man crawled out from under bodies. He ordered that execution. And Mr. Lauchi said, "I want to put to you that the defense is not taking a position as to whether what you say is accurate. That, in our view, will be for the chamber to decide whether miracles can be believed beyond reasonable doubt," which I reacted to at the time. I thought it was completely inappropriate. The length of time spanning the crime period, August through March of the next year, around about 8 months. That's a significant period of time, and I don't think you look at each, you shouldn't break it up into, well, on this day was Bindisi, on this day was Mukhtar. That's only 2 days, so it's not significant. This period he was active in hunting down the four, committing these crimes, extended over a lengthy period of time, and he's been charged for some incidences within that period. So I don't think we misstated there. And the amount of time it takes to commit a crime doesn't affect its severity. Just Srebrenica, 8,000 to 9,000 Muslim men and boys murdered in about a week. Doesn't make it not serious that it only took a week. On his medical background, which you asked some questions about, I would just add there to keep in mind, I think it is significant that he had this medical background. He knew how to treat people. In the Army, he had been a medical assistant, a nurse, and the defense, in their opening, had said that he treated people. Prisoners in Mukhtar, I won't go over the description of the conditions again. The 3 of them died while in detention. Nobody got any medical care from the medic who was holding them prisoner. And at paragraph 416 of the judgment, if I have the paragraph right, you found to refer to the instance of him reprimanding his Janjaweed forces for not taking the medication that was lying around a dead body. So just to sum up, because we've talked about it a lot, all these mitigating circumstances, Your Honors, I don't want to use a silly, it's like a gram of mitigation weighed against 10 kilos of the extreme gravity of these crimes. Unfortunately, I need to go into private session to talk about the report that we discussed earlier. 10 minutes.
Sorry, private session, please.
We're back in open session, Madam President.
Thank you, Your Honors. Now, I'm going to talk a little bit about the issue of whether a life sentence, a joint sentence of life imprisonment, should be imposed and some of the objections to that. First of all, my friends spoke the other day about his low rank of Musaid, saying he had the highest rank of Musaid. The rank is totally irrelevant. And, you know, he was a Musaid in the Army, then he was a Musaid in the CRF, and in between, he was the leader of the Yanuyid. And that's the period that we are concerned with. And in paragraph 396, Your Honors, you found that he commanded a contingent comprised of 6,000 Yanuyid in February 2004, around Mukjar. So 6,000 troops. That's a brigade. That's larger than your average brigade in terms of number of troops. Sorry, I don't know if this was in private session, but I don't think it hurts anything. I can say this. At T72, okay, it is open. P883 testified at transcript 72, pages 53 to 55. He was asked by the defense on the size of a brigade in the Sudanese army, the SAF, at the time. And the witness essentially said, well, I'm not sure exactly, but there's around 300 men in a battalion, and there's about 4 battalions in a brigade in the SAF at this time. And then my friend asked the question, so if we do, on the basis of this rough estimate, simple multiplication, if a brigade had 4 battalions by that time, that would mean that the number of men in a brigade would be around 1,200 men. Is that correct? And the witness says, approximately, I didn't bother much about these numbers, but says approximately. So for the local area at the time, 883 was a witness who would know what he was talking about. He commanded the equivalent of 4 brigades. So his rank as Musaid before, after, even if they called him that at the time instead of Agid al-Agada, is totally irrelevant. And the defense submitted that under Article 78.3, the Chamber can only impose a joint sentence of life if it has imposed at least one individual sentence of life for one of the counts. That is, in our submission, just wrong. My friends cited to various commentaries, including Trifterer, Shabas, Kassesi. We checked that and didn't find that to be the case. And in the 4th edition, 2021, Trifterer refers to the Nidaganda case in talking about this issue. In Nidaganda, the trial chamber imposed individual sentences between 12 and 30 years. And given that the highest individual sentences imposed was 30 years, the chamber, in their writing their judgment, considered and wrote that the overall joint sentence could only be 30 years or life. That is what the chamber in that case concluded. If you look at the sentencing judgment, paragraph 25, their honors in that trial wrote, Article 78.3 of the statute does, however, provide that any joint sentence of imprisonment may not exceed 30 years, unless the extreme gravity of the crime and the individual circumstances of the convicted person warrant a term of life imprisonment. And in 249, as the highest individual sentence is 30 years of imprisonment and the maximum imprisonment for a specified number of years is also 30 years, the chamber can only impose 30 years or life imprisonment as the overall joint sentence. So in that case, there is precedent. It's not binding on you. That was their interpretation. And it only makes sense. I mean, you can imagine a case with lots and lots of counts, each of which, this case perhaps, each of which would carry 30, 30, 30, 30. And it would be, it would not make any sense. It would be ludicrous to say that life couldn't be imposed. And I think what the defense are kind of hanging their hat on this.
Far in excess of any of the sentences that were passed so far at this court, and upon accused who were active for a far longer period.
Yeah. Well, that's one thing, but what they were arguing was that you cannot employ, you cannot pass a joint sentence of life imprisonment unless you find that one of the underlying counts carries a sentence of joint life imprisonment. So they were arguing that you could not, for instance, say 30, 30, 30, and impose a joint sentence of life imprisonment. That is not correct. And I think what they're kind of hanging this on is that if you look at 77(1)(b) of the statute, it states a term of life imprisonment when justified by the extreme gravity of the crime and the individual circumstances of the convicted person. So it says crime, not crimes. And that makes sense because that is talking about the applicable penalties following a conviction on a charge. But I'll end it there, but it's just clear from Nitaganda that that is not the correct interpretation. And just if I can come back, it's to the same point. When determining the joint sentence, Your Honors would take into account the amount of factual overlap between the different crimes. And you asked a question of me of that, and I didn't answer it very well the other day. But what we submit, Your Honors, is while there is some overlap between conduct underlying some of the crimes, not within these separate operations. Each operation is a separate criminal episode, and each one of those separate operations, Kaduma and Bindisi, that's one, Mukhtar and Delej, have distinct underlying facts. There is no overlap between the facts of those distinct operations. That is what we would say. So that's why 30 years alone would not be sufficient for the gravity in this case. And I'll just point out, Your Honors, Rule 145.3 states only requires one or more aggravating circumstance to impose life. And here, throughout the judgment, it's aggravating circumstance after aggravating circumstance. I went through those in my presentation on Monday. But it only requires one, and there were many more in this case. Your Honor made the point the other day that there were no sentencing guidelines for international courts and tribunals, and that's right, and that's because, as you said, each case has to be considered on its own facts, on its own circumstances. So simply comparing counts or charges is not going to get you to a just verdict and is not helpful.
Say, Mr. Nichols, I've always thought that that it is possible to at least draft some basic guidelines, because at the moment all sentencing is a bit like this, with people just throwing figures around.
Well, that
Yeah.
probably could be very helpful as long as they weren't mandatory, and you maintained your discretion. But I'll also just take you to the Lubanga appeals judgment, paragraphs 76, in which case the appeals chamber stated, while recognizing that a previous decision on a sentence may indeed provide guidance if it relates to the same offense and was committed in substantially similar circumstances, any assistance may be limited given the trial chamber's overriding obligation to tailor a penalty to fit the gravity of the crime and the individual circumstances of the accused. And that's where I say, well, I was going through all of those points yesterday. The appropriate and only just sentence in this case is a joint sentence of life imprisonment. And I won't spend time on this, but you've recognized in your decision on the presentation of additional evidence for this hearing we're going through, decision 1257, at paragraph 17, you noted, however, the Chamber accepts the CLRV's submissions while deferring to the Chamber's discretion on the admission of D16 evidence, that the Court is not bound by domestic sentencing practices and laws. So it's a very little help. I'm going to jump ahead a bit. My friends,
Well, how much longer have you got, Mr. Nichols? Because, I mean,
sorry.
No, if you can complete within 10 minutes, I'll say carry on, and we'll
I
complete
cannot.
it. No, that's what I thought.
I probably have about 20, 25.
Yeah. Well, I did think that was all right. In that case, we'll adjourn now until 9:30 tomorrow morning. Simply for timing, Mr. Lauchi, you think you've still got another whole session, so we're likely to go through till lunchtime, are we?
That's my expectation. Well, with the submissions of my learned friends not completed today, I would ask for their extreme favor, once they are done, to have, like, I don't know, a very short break to just digest and see if there is anything that I need to add to what I'm intending to say.
No objection to that from me, and I'll try to be quick tomorrow.
Yes. No, certainly, Mr. Lauchi. I mean, this is not an easy exercise. So, all right. We'll adjourn then, please, until 9:30 tomorrow morning.
All rise. We would